Welcome to the Law&Crime Network. My name is Bob Bianchi. I'll be taking it with you till 3 o'clock this afternoon. So, guys, we have a great benefit here in the Jonchuck trial. But this is really difficult. That's some of these names for yours truly. And this is Josh Solomon. You remember I had him on the other day. He's from the Tampa Bay Times, and he has probably the best knowledge in the media world with respect to this case. He's been following it really, really deep and in the flesh, and he's in the courtroom. Welcome back to the show, Josh.
Bob, thanks so much for having me.
So, you know, we got a lot of compelling testimony here. It's obviously an insanity case. The defense has called a couple of witnesses. I got my good friend Gene Rossi with me, and from the first couple of witnesses for the defense, we were asking, are they defense witnesses or prosecution witnesses? Are they helping the defense?
Yes, so the defense called one witness this afternoon before we broke for lunch, and it was an officer. The prosecution had called several officers, so we actually, a lot of what we heard today was repeat for the defense witness. But what they, I think what they're really trying to drive home is that in the moments that Jonchuck was apprehended, he was gripping the steering wheel. He was looking straight forward. He was, he felt distant, perhaps not like someone who had just done something violent and erratic, felt sort of not there, not with it, and that's what they need to prove if they're going to have a successful insanity defense.
So right now, Josh, I know it's kind of premature to say this, but are you seeing it as a dogfight here about this insanity defense? Is it going to be a close call in your mind, or is the prosecution blowing it away, or the defense blowing it away?
Yeah, it's really tough to tell. I mean, the state went first, and their job initially in their case in chief was simply to prove that he did it. And they really had no trouble proving that. I mean, Jonchuck dropped his daughter Phoebe off a bridge in front of a police officer. He was apprehended shortly thereafter. The chain of events here was witnessed from start to finish by sworn officers who make for good witnesses. So they didn't have a lot of trouble proving he did it. The real fight is going to come in the why. The what, as I said, the what is provable. It's going to be the why. And both sides are going to put forth, competing narratives.
What about expert witnesses? Typically, when you're trying to go for an insanity defense, you're going to get some medical testimony out there. Do we have any insight as to what the defense is going to do in that regard?
Yeah, so both sides have lined up some doctors. The defense, I believe, has three who evaluated Jonchuck and made the claim that at the time of the incident he was insane. Because that's really what's important. It's not what his mental state is right now that's important. It's what was his mental state at the time. To contradict those doctors, the state has their own doctors who will get on the stand and who are expected to say that Jonchuck wasn't insane. So we'll see, which experts are more persuasive to the jury.
Okay, so we have an idea of how you would do this as a defense lawyer. You tee up a couple of witnesses. Obviously, they have to be police officers because they were at the scene at the time of the incident to say he was kind of acting erratically or strangely. And you're going to put your experts that are going to say that those facts, and including previous probably commitments as well as a previous mental health history, they're going to come to the opinion that he was legally insane at the time. Do you expect the defense is going to call any more of a case than that?
Yeah, I think we anticipate that they'll be calling friends and family. Jonchuck started in the days and weeks prior to Phoebe's death. He was acting erratically. He was salting his home to try to ward off evil spirits. He was carrying around an enormous Swedish Bible that he was asking people to read. And I think they're going to try to demonstrate that all of that, speaks to his perhaps deteriorated mental state. So they are going to call people who were close to him, people who are going to be able to say, or at least describe his strange behavior to the jury.
Josh, I have two more questions for you. The first is, after the defense is done with its case, do you have any indication if the defense, or if the state rather, is going to put on a rebuttal case?
They are. So the defense, has the burden of proving that he was insane. In Florida, the defense has that burden. And then the state, so really the roles kind of switch from here on out. The defense has the burden, and now the state has the burden, the role of sowing doubt. And they, they've already lined up a couple of expert witnesses who are going to say that he was not insane. The burden of proof here is by clear and convincing evidence. So the defense does have a little bit of work to do in terms of making sure there's enough doubt that the jurors can't find him insane by clear and convincing evidence.
Well, this is a legal question, not a reporter one, but I'll put you on the spot. If you don't know it, I completely understand.
Okay.
In many states, the way this works is that the defense has to prove by either a preponderance of the evidence, or in Florida, I guess it's clear and convincing evidence, there's a mental disease or defect that he was suffering under at the time of the incident that essentially deprived him of his ability to form an intent to commit a crime. And then in other states, the burden then shifts back to the prosecution that has to disprove that defense beyond a reasonable doubt. Does that make sense to you there? Or?
Yeah, and that's the way the law used to be in Florida up until 2000. And since then, now once evidence is introduced that the defendant was insane, it remains the burden of the defense to prove that. Up until about 2000, if the defense introduced evidence, then the presumption, then the defendant was then presumed insane, and it was the state's job to prove that he wasn't. You know what I mean? Now I'm talking myself in circles, but the way it works these days in Florida is that the defendant is presumed sane throughout, and it's the defense's job to prove by clear and convincing evidence that he was insane.
Okay, yeah. So I guess that's just an interesting little, anecdote about how those things move along that way. Josh, hey, listen, I really appreciate it, bud. You're always doing a great job and giving us tremendous insights from that courtroom, and I hope and I assume we're going to have you back, right?
I hope so. It's day 3, so I'm happy to come back as many times as you'll have me.
All right, great. Josh Solomon from the Tampa Bay Times. Thank you so much for those insights.